Despite the opposition to judicial elections, many of the criticisms of them may also apply to judicial appointments. While many judicial election opponents take issue with the fact that the candidates take positions on the important legal issues of the day before they're even elected, supposedly compromising their judicial independence, judges appointed by executives are usually selected based on their ideology and positions on the issues as well. For example, President Trump pledged to appoint judges who would seek to overturn, or at the very least to undermine Roe v. Wade. While these judicial nominees may not state their positions on these issues explicitly during their confirmation hearings, it is likely that they give the president their word that they will support their legal agenda. In addition, another criticism of judicial elections is the amount of money that is spent on them, and that the appearance of judges accepting the financial support of interest groups and corporate executives does resemble that of corruption. While this may be true, outside spending is still strong on both sides during high-profile Supreme Court confirmation battles. In 2018, when President Trump nominated Brett Kavanaugh to replace the retiring Justice Kennedy, it opened the floodgates for both sides to spend big on supporting and opposing his nomination. His nomination was particularly important because Justice Kennedy, despite leaning right on most issues, was seen as the most moderate member of the High Court, especially on social issues. Kavanaugh on the court feared liberals would shift the balance of power further to the right for decades to come. Liberal advocacy group Demand Justice spent $5 million on ads opposing Kavanaugh, targeting in particular potential swing votes in the states of senators such as Susan Collins of Maine, Lisa Murkowski of Alaska, and Jeff Flake of Arizona. One of their ads highlighted Christine Blasey Ford, who accused Kavanaugh of sexually assaulting her when they were college students, a charge which the Supreme Court nominee denied. The ad showed her at a hearing before the Senate Judiciary Committee, juxtaposed with audio of President Trump mocking her. During that same hearing, Kavanaugh blasted the outside groups that were spending to oppose his confirmation, saying he believed, quote, millions of dollars in money from outside left-wing opposition groups, and, quote, were behind the effort to sink his court bid. He also said, quote, this whole 2-week effort has been a calculated and orchestrated political hit. However, the Kavanaugh confirmation battle was not the first one in which outside groups on both sides spent big. In 2005, President George W. Bush nominated Samuel Alito to replace retiring Justice O'Connor. Like Kennedy, O'Connor, while certainly leaning to the right overall, was considered a social moderate, and liberals believed that Alito would be a reliable vote in the conservative direction in cases on social issues. They believed he would undermine civil rights, free speech, Roe v. Wade, and the separation of church and state. Conservatives, on the other hand, touted the American Bar Association's rating of Alito to be highly qualified to serve on the High Court. Outside spending, both for and against Alito's nomination, was big, with liberal groups spending nearly $1.4 million to stop him from getting on the court, while conservatives spent just over $1 million to encourage the Senate to confirm his nomination. These ads, as well as grassroots lobbying done by these interest groups, targeted senators on both sides of the aisle who, in the past, had shown willingness to break ranks with their party on judicial nominations. These targeted senators represented states including Arkansas, Maine, Montana, Rhode Island, South Dakota, and West Virginia. In the end, despite being outspent by outside groups, conservatives won, and the Senate confirmed Alito's nomination in a 58-42 vote in January 2006. The failure of liberals to convince people that he was an out-of-touch right-wing ideologue was in part due to his presentable conduct during his confirmation hearings and his refusal to explicitly state his positions on hot-button issues. In fact, he cited the landmark case of Griswold v. Connecticut as a super precedent, or a case that he believed was settled and could not be overturned under any circumstances. To the average American observer, this disproved liberals' case. Although not necessarily an example of outside spending in support of or opposition to a Supreme Court nominee, the aftermath of Justice Ruth Bader Ginsburg's passing is an example of the increased partisan polarization when it comes to these nominees. On September 18, 2020, Ginsburg passed away, and President Trump promptly promised to appoint a replacement, despite the presidential election being less than 2 months away at the time. The day after Ginsburg's passing, he texted his supporters about his intention to fill the seat, as well as to solicit donations to his re-election campaign. Meanwhile, Democrats broke their fundraising records through ActBlue, their online fundraising platform, raising over $42 million within less than 24 hours of the passing of the late justice. This previous record had been set just over 3 months earlier, following the murder of George Floyd by a Minneapolis police officer. In addition, a record-breaking $6.3 million was raised within 1 hour of the night the news of Ginsburg's death was announced. Much of this fundraising was allocated towards Democratic candidates running against vulnerable Republican senators who had pledged their support for President Trump's eventual nominee. Kamala Harris sent an email to supporters soliciting donations with a message stating her belief that Ginsburg's replacement should not be chosen until after the election. Explaining the surge in donations, Democratic fundraising consultant Tanya Rosencrantz, said, quote, Democrats are taking their rage and channeling it how to use it for good, and that's their contribution. Their dollars are working for change. We have the infrastructure there for this moment. The people know this is their greatest impact they can make. Quote, due to the overlapping problems with judicial elections and appointments, most notably the outside spending from interest groups and political parties on both sides, it makes sense to consider a hybrid system. This is known as the Missouri Plan, which is used in some form by 3/5 of the states, such as Missouri, as the name would imply, as well as Arizona, Indiana, Kansas, Tennessee, and Utah. The way it works is that a judicial nominating commission is created to evaluate potential candidates for a judicial seat and sends a short list of their recommendations to the governor, who would usually then select their nominee from that list. After one term, the nominee would face the voters for a retention election to keep their seat. Authors such as Burt Bradenberg and Roy A. Shotland advocate for this method, as it, quote, results in a dramatically less expensive campaign than nonpartisan or partisan contestable elections. Although they acknowledge that it is the most difficult form of judicial selection to achieve, they note its rising popularity, at least when compared to the plummeting popularity of judicial elections. Authors such as Martin Siegel have also suggested retention elections as a potential judicial election reform, although he states that nonpartisan elections generally result in lower turnout. One reform he suggests is public financing of judicial elections. He notes how states such as New Mexico and North Carolina have adopted this system of financing for their state judicial elections, and, at least in the case of the latter state, candidates who opt into it have fared better in elections than those who do not. Additionally, the overwhelming majority of North Carolina voters support the system. Not only that, but it has also reduced the amount of private money that judicial candidates receive, thus boosting their reliance on small-dollar individual contributions, and not large campaign checks from special interest heads or corporate executives. Quote, once my campaign raised the required funds to qualify for public financing, wrote one judge who opted into the public financing program during their election, I was then free to spend the remainder of the campaign focusing on my record, my qualifications, and not on fundraising, end quote. Given the success of public financing systems for judicial campaigns in several states, if other states and the nation as a whole are going to use judicial elections to select judges, they must allow candidates to opt into such a system in order to prove their independence from the influence of corporations and special interests. However, public financing of judicial elections alone is not enough to ensure candidates' independence. Limits on outside spending must also be placed in order to fully ensure that a judge will remain independent from outside influence in their decision-making. However, with the Supreme Court's Citizens United ruling, Congress and the states do not have the authority to enact these limits in the absence of a constitutional amendment, which is extremely difficult to pass, especially in such a hyper-partisan Congress. As such, judges who are only elected and never appointed create the appearance of being beholden to the influence of big-money donors and spenders. Additionally, as Lambda Legal argues, leaving the judicial selection process solely up to the voters puts basic human rights at risk, as a solidly conservative state's electorate would be more likely to elect anti-LGBTQ+ and anti-abortion rights judges. Indeed, as studies mentioned above has shown, directly elected judges are more likely to hand down harsher sentences, increasing America's already sky-high incarceration rate. This is a strong indicator that judicial elections on their own are not a just method of selecting judges. However, leaving the power of judicial selection purely to the executive and the legislature is also a misguided idea. The American public, when asked about their opinions on Congress, consistently are transparent in their disapproval of the performance of the legislative branch. Additionally, with how partisan Supreme Court confirmation fights have become in recent years and decades, and the aforementioned evidence that partisanship and ideology is not generally a key factor in how constituents vote in judicial elections, it is clear that the voters value an independent judiciary more than members of Congress, and more than interest groups on both sides that spend big to influence these confirmations. By holding retention elections, which are not nearly as partisan as judiciary elections, or even nonpartisan ones, for that matter, and enacting this reform in addition to other aspects of the Missouri Plan, voters will not be forced to pick between two candidates who may not even be qualified to become judges, but rather whether or not the individual selected is well fit for the judicial position. While judicial elections have their upsides, the downsides of potentially electing judges who will undo basic human rights, and the public opinion demands so of them, or who do not possess the necessary qualifications to serve on the judicial bench, it alone cannot be the method for judicial selection in the United States. Additionally, with the majority of Americans believing that elected judges are more beholden to their donors than they are to upholding the rule of law, opinions which are borne out by data, in the absence of meaningful campaign finance reform, most importantly setting strict limits on outside spending, Judicial elections will be parallel to the current process, in which outside groups on both sides spend big to influence public opinion on Supreme Court nominees. However, the idea that executives and legislatures, much of the time, appoint and confirm judicial nominees who are ideologically similar to them first and foremost cannot be ignored, as many judicial nominees that fit this description have been given an unqualified rating by the American Bar Association. As such, a compromise position between these two methods is necessary. The Missouri plan is exactly that compromise. It is the best method because it allows the most qualified nominees to be appointed as judges, while also making sure that the voters are satisfied with their performances. The Missouri plan strikes the vital balance between judicial independence and judicial accountability. While no judicial selection system is perfect, the Missouri plan is the one that comes the closest to having independent-minded judges, ones who are chosen mostly because of their qualifications, not their partisanship and/or ideology, and those who are accountable to the public whose decisions they will impact.